morning everyone, and a really warm welcome to our third webinar of the year, which is our autumn webinar. My name is Catherine Andrews and I'm a partner in our construction and engineering team here at Burkitt's. Can we have the next slide, please? So this is just some brief information about the firm, which will be on the slides when you receive them. Hopefully you know a little bit about us, but we are a top 60 full service law firm with offices across East Anglia and London. Next slide, please. Firstly, I just wanted to take the opportunity to introduce you to our panel for today. So firstly, we have Katrina Bretten, who is a solicitor in our construction team in Cambridge, and she's a senior associate, and she's your go-to person for non-contentious construction work at the inception of projects and all the project documentation. Those of you familiar with the format of our seminars will know that we like to also involve some of our colleagues from the firm. And today our guest speaker is Matthew Weston, who's a legal director in litigation in Chelmsford, and he specialises in insolvency matters. Unfortunately, at the moment, following Brexit and COVID and all the issues with material price rises and labour shortages, unfortunately we're seeing more insolvencies, so we thought this would be a useful topic to discuss today. And last but no means least on our panel is Emma Chiaramello. She's a senior associate in our construction and engineering team, also in Chelmsford, and specialises in contentious litigious construction matters. So welcome to everyone and thanks for joining us today. Next slide, please. So this is just a summary of what we're going to be talking about today. Somewhat surprisingly, when we do these seminars, a lot of the questions we have in the feedback relate to collateral warranties and third-party rights. So we thought we'd try and wrap all of that up in a session today. So that's what Katrina will be talking about. Thereafter, Matthew will be looking at insolvency and construction contracts, and Emma will be providing a whistle-stop tour through some of the recent construction cases which might be of interest. And then finally, we'll come back for a short Q&A session with the panel as a whole. So there will be an opportunity to put questions to the panel through the chat function in the GoToWebinar portal. The questions come through to me only, and so they will remain anonymous, so please don't feel shy about sending them through to us. We also had a good number before the session, so we'll try and get through as many as we can, but apologies if we don't get to them all. We can come back to you. We'll look at drawing proceedings to a close promptly at 12. Just to let you know that within the next week, we will send you the slides and all the information from the webinar as a follow-up. And also this session and any previous sessions that we've done can be reheard on the Burkitt's YouTube channel. So next slide, please. Without further ado, I will now hand over to Katrina, who's going to talk to us about collateral warranties and third-party rights. Thanks very much, Katrina.
Thank you, Catherine, and good morning, everybody. Now, for those of you who make up the professional team, the notion of collateral warranties or third-party rights will most commonly be raised by your employers, be that end users or main contractors, for themselves or on behalf of certain beneficiaries. But why are they necessary? Well, I thought we'd start by looking at some legal principles. So can we have the next slide, please? Firstly, by virtue of the doctrine of privity of contract, until May 2000, it was the case that only the parties to that contract could acquire enforceable rights or obligations under it. Alternatively, and in the absence of a contract, it is possible to bring an action in the tort of negligence. However, following the case of Murphy versus Brentwood in 1991, it's no longer possible to bring an action in negligence for pure economic loss, that is to say the financial as opposed to physical damage caused by a party's negligence. In that case, the claimant unsuccessfully pursued the local authority for damages in the reduction of value to his property after the local authority negligently approved plans for the footing of his house. Now, the footings were defective, which caused the house to subside, and the claimant was forced to sell the property at a loss as he couldn't afford the cost of the repairs. However, in rejecting the claim, the House of Lords held that to allow the claimant to recover damages for the money which he'd lost on the sale of the property or for the cost of repairing it would result in an unacceptably wide level of liability, which would effectively amount to judicial legislation introducing product liability and transmissible warranties for defective buildings. Next slide, please. As such, third parties began to devise mini contracts to circumvent the privity of contract rule, and collateral warranties were born. Now, when negotiating your collateral warranties, there are a number of clauses and points that you'll need to consider. Firstly, as the name suggests, the warranty is collateral to the principal contract itself, and so the rights and obligations which arise under it will only ever be as good as that underlying contract. As such, the key obligation in any warranty will always be a warranty and undertaking on the behalf of the warrantor that they have and will continue to comply with their principal obligations under that contract. And if that's all the warranty says, then typically it would be fine. However, rather than simply relying on this overarching obligation, warranties invariably include specific additional obligations, and I'll highlight a few of those key clauses now. The first is an obligation to use the level of reasonable skill, care and diligence as can be expected of a designer undertaking design of the works. This is commonly referred to as the required standard and reflects the fact that warranties are generally provided by those with design responsibility only, be that traditional designers such as architects and engineers or contractors responsible for an element of design. It also reflects the fact that the scope of liability under a warranty should be for negligence only, and so parties should not accept that the required standard should require the warrantor to act in the capacity of a contractor, as the implication then is that the warrantor would be providing a product, and so that would imply fitness for purpose liability. Secondly, warranties will include an obligation to maintain professional indemnity insurance, and again this should be coextensive with the principal obligation in the underlying contract, both as to the level and scope of insurance and also the duration of cover. Now, this requirement to maintain insurance should only apply so long as insurance is available at commercially reasonable rates and on commercially reasonable terms, something which is going to be ever more important over the coming years given the hardening of the PI market. And it just reflects the fact that warrantors shouldn't be required to go above and beyond what is commercially reasonable in the marketplace in order to maintain insurance. Although it's generally accepted that where more onerous terms or additional premiums are imposed due to the warrantor's own claims history, this will still fall within the definition of what's reasonable. Now, if the warrantor, for whatever reason, isn't able to maintain insurance at the stated level, the parties should be required to discuss the best means of protecting their respective interests under a warranty. Now, this could include maintaining cover at levels lower than specified in the warranty, or cover above that which is reasonable in the marketplace at the particular time, provided, of course, that the beneficiary is willing to pay the additional premiums. Can we have the next slide, please? Moving on then, warranties will also include clauses dealing with copyright and assignment. Again, following the collateral nature of the warranty, the terms of any copyright license granted should generally follow that in the principal contract. However, it is nonetheless important to check that the definition of documents extends only to those that the beneficiary is likely to use going forward, and not anything that you're not willing to share. Similarly, the uses authorised by the licence should be acceptable. Now, one common caveat is that whilst warrantors are generally happy to allow beneficiaries to use documents for the purposes of any extension, this should be on an information-only basis and should not extend to the physical reproduction of any designs in an extension of the works. And finally, a warrantor will want to ensure that they're only liable for use of the documents where the beneficiary has used them for the purposes that were originally intended, and the warrantor shouldn't be liable where the beneficiary has effectively misused those documents. Now, when it comes to assignment, warranties are generally freely assignable unless the warranty specifies otherwise. And following a rather tedious study many years ago now, it was found that typically a collateral warranty would be assigned twice prior to the expiry of the limitation period. And this is why you'll see warranties allow a limit of 2 assignments only. In addition to those permitted 2 assignments, beneficiaries do, however, request assignments to and from group companies and or funders, including any reassignment on redemption of that security. This is generally fine, but before accepting any such extras, you'll need to double check the terms of your PI policy, as some insurers provide that warranty should only be assigned twice and won't extend cover beyond those permitted 2 assignments. But regardless of however many assignments are permitted under the terms of the warranty, a beneficiary will want to ensure that the warranty provides that assignees are entitled to recover any losses that they may incur as a result of a breach of that warranty, even where the original beneficiary perhaps wouldn't have suffered that loss either to the same extent or at all. And this is often referred to as the no loss wording. Can we have the next slide, please? Moving on then to look at step-in rights and limitations of liability. Now, step-in rights are typically requested by funders and are intended to ensure that a project can continue, even where the employer under the underlying contract is in breach. And this is because they require the warrantor to serve notice of an intention to terminate that principal contract and to effectively give the beneficiary an opportunity to put right that default and step in to perform the employer's obligations moving forward. Now, any notice provisions under the step-in rights shouldn't affect the statutory right of suspension, which will apply on not less than 7 days' notice. And as a precondition of exercising a step-in right, the warranty should provide that the beneficiary is obliged to pay any outstanding sums due under the principal contract at the time of step-in. Finally then, looking at limitations of liability, as I've mentioned, the warranty is collateral to the main contract, and so liability under that warranty should be coextensive with that under the main contract itself. This should be both in terms of the duration of liability, and so there should be an equivalent limitation period. Also that the warranty should impose liability which is no greater value than that which would apply under the main contract itself. And when it comes to step-in, unless and until a beneficiary has exercised any right of step-in, the warranty should also provide that the warrantor will not be liable for any delay in completing the works. Moving on then to the next slide, please. And now looking at the alternatives to collateral warranties. Now, from May 2000, the Third Party Rights Act was introduced as a means of circumventing the doctrine of privity of contract. And one of the stated objectives of the Act was to allow subsequent purchasers or tenants of buildings to be given rights to enforce an architect or building contractor's contractual obligation without the cost, complexity and inconvenience of a large number of documents. However, rather helpfully, the construction industry responded by limiting the operation of the Act from construction contracts. And so you'll commonly see the inclusion of the clause at the top of this slide included. Where, however, third-party rights do apply, it's worth noting that the Act deals solely with benefits conferred on third parties. It cannot impose a duty on those third parties in respect of the principal contracts or bind the third party to give up any right. Some of the key provisions then in relation to third-party rights, which much like collateral warranties will apply to the same beneficiaries such as purchasers, tenants, etc. There are 2 methods for drafting these third-party rights, either by way of a standalone schedule or a schedule identifying specific clauses of that contract, which the third-party is then able to enforce. Either way, third-party rights generally extend to an obligation to comply with the principal contract itself, a duty of care to perform these services, and an obligation to use the required standard, so reasonable skill, care and diligence in the execution of the works and or provision of the services. The same limitations of liability under the contract will also apply in much the same way as collateral warranties, and there'll be an obligation to use the required standard when specifying materials. Again, the third party will also require a copyright license to copy and use documents for the permitted purposes, and they'll also require the original party to the contract to effect and maintain professional indemnity insurance, as well as the ability to assign the benefit of the third party rights on, which in the usual way will be subject to the usual 2 limits plus any extras that may be agreed. Now, where third party rights are granted for the benefit of funders, those funders will require additional rights, including that of step-in for the purposes we've already mentioned. Next slide, please. Looking then at some of the advantages and disadvantages of third party rights. Obviously, the main advantage of third-party rights for employers is that they're much more convenient. All the employer has to do in order to give effect to third-party rights is serve notice on the relevant party that the rights have been granted. They don't have to deal with pieces of paper passing from one party to another or DocuSign envelopes being bounced along before the warranty can finally be executed and completed. Now, whilst from a contractor's perspective, this is quite useful in that there's no danger of practical completion being delayed for non-provision of warranties, they do, however, lose an element of control over the process because the third-party rights are effectively granted without reference to them. And for that reason, they're also only really appropriate where the employer has appointed the main contractor and the consultants direct, because they then have control over service of the relevant notices, and so they're not relevant for other members of the supply chain, such as subcontractors. Now, notwithstanding the ease of third-party rights, they've perhaps not been quite as popular as we might have expected, and collateral warranties do generally still reign supreme. This is because beneficiaries like the tangible nature of having a separate document that's executed as a deed, and also they're probably just a little bit more familiar to everybody. It's also easier to grant step-in rights in a collateral warranty as opposed to third-party rights, as I've mentioned, and this is because, as I've said, it's not possible to impose an obligation on a third party to incur liability under that contract, and so the precondition of paying any outstanding sums due under the contract as a condition of exercising step-in rights wouldn't apply. However, the key benefit of a collateral warranty is that following the case of Parkwood Leisure back in 2013, they can be construed as construction contracts and so fall within the scope of the Construction Act. This means that the beneficiary would be entitled to refer any dispute to adjudication in the first instance, which is obviously much cheaper and quicker than legal proceedings. Now, whilst the case of Toppin last year held that this would only apply where construction operations were continuing, and so the notion of warranties needed to be completed before practical completion of the works was born, this was subsequently overturned in the case of Abbey Healthcare last year. Earlier this year. In that case, the Court of Appeal concluded that, depending on the wording, collateral warranties can be construed as ongoing promises for the future, and so would constitute an agreement for the carrying out of construction operations, therefore bringing them within the scope of the Construction Act and having the benefit of adjudication as a dispute resolution mechanism. Now, that's all from me. I'm going to hand you over to Matthew Weston on the next slide, who will talk to you about insolvency in the construction industry. Thank you.
Thanks, Katrina. Good morning, everyone. Can I have my first slide, please? To start with, I've set out the last 6 quarters insolvency figures, which I've obtained from the Insolvency Service. You'll see there's been a steady increase in the number of insolvencies over this period. To give you some further context, construction companies account for 19% of the overall insolvencies, and 1 in 257 active companies has gone into insolvency over a recent 12-month period. During the pandemic, insolvency numbers were suppressed by fiscal support from the government and the temporary restriction on winding up petitions. Insolvency numbers are expected to continue to rise given the likely increase in interest rates and in the cost of raw materials. There are 4 main types of insolvency. The 2 types of liquidation are both terminal procedures. compulsory liquidations are commenced by creditors through the court, and creditors' voluntary liquidations, CVLs, are commenced by the company's shareholders. By way of contrast, administrations and CVAs, company voluntary arrangements, are non-terminal procedures designed to ensure the survival of the relevant business. There's also a new kid on the block, a new procedure introduced in 2020 called the Part A1 moratorium. This is a temporary procedure giving a business 20 days protection from its creditors whilst a rescue plan is formulated by an insolvency practitioner. However, you'll see from the numbers on the screen that the take-up of this new procedure has actually been very low. The four main types of insolvency listed on the screen, namely compulsory liquidations, CVLs, administrations, and CVAs, all fall within the definition of insolvency in a typical JCT contract. The new Part A1 moratorium isn't, however, included within that definition. Can I have my next slide, please? During the first lockdown in 2020, substantial changes were made to suppliers' rights to terminate contracts when their counterparty was insolvent. These changes don't just apply to construction contracts, they apply across the board. These new provisions are permanent, they're not restricted to the lockdown period. To put these changes into context in the construction sphere, I've set out the main termination provisions in the JCT Design and Build Contract 2016, starting with the employer's termination rights and then setting out the contractor's termination rights. On the face of it, both employers and contractors can terminate by serving notice upon the default or the insolvency of the counterparty, but matters are no longer quite so straightforward. Could I have my next slide, please? This slide sets out the text of the new provisions in the Insolvency Act, which restrict a contractor's ability to terminate contracts in the context of his counterparty's insolvency. Subsection 3 disapplies termination upon insolvency clauses. So clause 8.10 can no longer be relied upon by a contractor to terminate a contract. Subsection 4 disapplies termination upon default clauses, but only after the employer's insolvency has commenced. So clause 8.9 of the JCT contract can no longer be relied upon by a contractor after the insolvency of his employer. These are far-reaching provisions. Their purpose is to assist insolvency practitioners in rescuing viable businesses, for example, by stopping contractors from exercising commercial leverage by insisting on outstanding bills being paid before jobs are completed. I should mention that the insolvency practitioner will be responsible for ensuring payment for works carried out post-insolvency from the insolvency estate. It's not going to be easy to get around these provisions. Contractors may need to ensure their contracts have robust termination for default provisions, which are exercised before the employer goes into insolvency. Employers' termination rights aren't affected by these provisions in the Insolvency Act. My next slide, please. This slide covers an insolvency aspect of retentions. The standard JCT contract specifies that the retention held by the employer is held on trust and must be kept in a separate bank account. I understand that these clauses are often negotiated out of the contracts, but if they're retained, so far so good. On the face of it, this should protect the contractor on the employer's insolvency. Funds on trust don't vest in the liquidation or the administration. However, there won't be a valid trust unless the contractor actually complies with its contractual obligation to keep the retention in a separate bank account. Experience suggests that this almost never happens. So the protection of this clause is likely to be illusory. It would be better for the contractor if another mechanism is adopted for the purposes of retention, for example, the provision of retention bonds. My next slide, please. This slide sets out some suggestions if your counterparty enters insolvency. First of all, I've included a warning about the wide effects of winding up petitions. If a customer pays you when it has a winding up petition issued against it and is subsequently wound up by the court, the payment to you will be void and claimed back by the liquidator. There's very little that can be done about this, but the action that's necessary is to keep up-to-date information and searches on the counterparties to your contracts. In all insolvent liquidations, creditors have the ultimate power to choose who the liquidator is. But often this doesn't happen, and the creditors are left with the insolvency practitioner chosen by the directors of the insolvent company. This is often to their detriment. You only have to be given 3 business days notice of a liquidation, so time is critical if you want to nominate your choice of insolvency practitioner for the liquidation. Finally, a note on proofs of debt. Proofs of debt are how you submit a claim within a liquidation. It is for the liquidator to adjudicate on proofs of debt. If a liquidator rejects your proof of debt, you only have 21 days in which to appeal that rejection to the court. The same time limit applies for solvent as well as insolvent liquidations. In solvent liquidation, a creditor will by definition be paid 100 pence in the pound in respect of claims accepted by the liquidator, so your interest will be greatly prejudiced if your proof of debt is rejected and you miss the 21-day deadline for appealing to court. So to conclude, the termination provisions and some other provisions in construction contracts may not operate as drafted upon the insolvency of a counterparty. The best time to mitigate the consequences of the insolvency of the counterparty is at the outset of the transaction, as opposed to when they have actually entered insolvency. I'll now hand you over to Emma for her case law update.
Thank you, Matt. I'm going to be taking you through a few recent cases. We've got a couple of cladding cases, one relevant to liquidated damages and 3 adjudication enforcement cases to look at. Next slide, please. Thank you. So the first one we're going to be looking at is the case of Martlett and Mullally. It's July 22, this was decided. It arises out of a refurbishment of 5 1960s built tower blocks. Mullally installed the Stotherm Classic cladding system. The buildings were all over 18 metres as well. It was found that on investigation following Grenfell that there had been insufficient or incorrect fire stopping cavity barriers installed. And Martlett took the decision to remove and replace the cladding system entirely. So Mullally claimed that there had been a cheaper remedial scheme available and that they had BBA certificates showing that the relevant cladding system was compliant with the building regulations at the time that the system was installed. The court didn't like this argument, took a strict approach. It held that the system was not compliant with the building regulations that were in force at the time of the refurb, and that was the case regardless of any installation defects. They weren't happy that the BBA certificates evidenced compliance with the building regulations, and they went on to award £8 million worth of damages to Martlett. That included the cost of the initial investigation, the waking watch costs that included the removal and the replacement of the cladding system. Next slide, please. So what can we take from this? We can see it's perhaps not surprising, the decision, but it does show really the strict approach that's going to be adopted moving forward in respect of such claims by the TCC. The key factor in most cases is going to be the suitability of the remedial scheme, and that will be looked at on a case-by-case basis. It's notable because it confirms that the costs of a waking watch are recoverable, albeit that in this case, only the costs of one fire marshal were upheld rather than the two that were used by Martlet. Interestingly, buildings, it was held that buildings that haven't been tested in accordance with BS 8414 are unlikely to be found compliant with building regulations. So what can we take from it? We can take that it's key to get those relevant tests sorted in order to have the evidence of compliance. Another key thing to bear in mind is if you are anticipating any such claims, you need to start engaging with relevant subcontractors with a view to considering how you would justifiably pass down any liability that may accrue to you. Next slide, please. So next case we're looking at is another cladding one. It's Orchard Plaza versus Balfour Beatty. This is a cladding claim brought under a collateral warranty. It was in relation to fire safety defects. The collateral warranty was actually granted by Balfour Beatty to the funder. It was then assigned to the freeholder and reassigned to the management company of the block. The main argument by Balfour Beatty was that the loss was claimed based on the remedial costs associated with replacing the cladding, and that was too remote because at the time of signing the collateral warranty, they hadn't anticipated such losses. It was only granted to the funder. The likely loss by the funder would have been the diminution in value of the funder's security. So effectively, the contractor was trying to escape all liability because it was a claim under a collateral warranty as opposed to a building contract. Next slide, please. So this didn't go down very well. The TCC held in favour of Orchard Plaza. They found that the loss was not too remote. It was within the reasonable contemplation of Balfour Beatty when they signed the collateral warranty. This is also reassuring for those beneficiaries of a collateral warranty because the courts held that the no loss clause in a collateral warranty, which Katrina mentioned earlier, is effective in preventing any such remoteness arguments as well. So we can see again there's a strict approach. Courts won't allow an easy escape from liability based on remoteness or based on an argument that it's only a claim under a collateral warranty, and reinforces the effectiveness of collateral warranties in general. Next slide, please. So our next topic is liquidated damages. As many of you will know, the regime of liquidated damages or liquidated and ascertained damages is effectively a better deterrent for delay in the sense that you have a predetermined rate, financial penalty, if you like, for delay. Sometimes these clauses can preclude a general damages claim for delay, i.e. you can only recover the weekly or monthly rate or daily rate based on how late you were, rather than a general damages claim for all losses arising out of the delay. Sometimes that's exhaustive under most standard form contracts it is, but that's not always the case. It does depend on how the contract's interpreted. So Buckingham versus Peel, this was a contract, a JCT design and build contract for the construction of a manufacturing facility for Peel by Buckingham. It's a bit unfortunate how the contract had been put together. There was a bespoke liquidated damages regime which incorporated Schedule 10 of the contract, which had been a travelling draft document between the parties when they were negotiating liquidated damages rates. So Schedule 10 said that it overrode anything stated in the contract and was later incorporated into the contract. There were a number of drafting errors in that document as well, which resulted in avoidable uncertainty. There's 4 big errors in it that the court looked at. So Buckingham sought declaratory relief on the basis that it was void for uncertainty, essentially, because it couldn't be applied. Their arguments were rejected by the court, who found that the provisions were certain, enforceable, and construed them to give effect to the parties' intentions. So the court looked through all of the issues, uncertainty issues surrounding this Schedule 10, and construed them to give effect to what it saw as the parties' intentions. Because this document had been a proposal document that had been travelling between the parties during negotiation and superseded by changes in the contract sum and in the completion date and things like that, there was a lot of uncertainty arising out of it, but the court actively sought to construe it and apply it, because that's what the courts like to do. The court also found that the cap in the contract, which stated maximum liquidated damages 1.9 million, would not be effective in precluding any claims based on any general damages claims. Next slide, please. What can we take from this? Again, we can see the courts are reluctant to interfere with what it construes to be the parties' intentions. They'll find a commercial common sense interpretation and try to give effect to it where they can. Reluctant to find that clauses are unenforceable for uncertainty as well. That said, we still do need to have very clear provisions in relation to liquidated damages and caps on liability, because this whole case and all the arguments could have been entirely avoided had there been a sanity check at the end. And I can only emphasise how important that is, because this case took a couple of years to go to trial, and it shouldn't have needed to, because it was all avoidable. Next slide, please. So we're going to look at a few adjudication cases now. The first is in relation to Bexheat and Essex. Bexheat was a plumbing subcontractor to Essex, who was a subcontractor on a job. There had been 2 relevant interim payment applications, interim application 22 by Bexheat and interim application 23. So there was also 2 adjudications. So the first was in relation to the true value of interim application 22. So the adjudicator was appointed to decide what should be paid to Bexheat following on from that application, and a decision was reached. Bexheat then made its application 23, and there was no pay less notice in relation to application 23. So there was subsequently a second adjudication, and it was found that the notified sum notified by application 23 was due and payable by default, irrespective of the fact that there had been a true value adjudication in respect of application 22. This was went to enforcement, and the court held that the true value decision couldn't be offset against the second adjudication based on the default payment. This was because there were different disputes and different payment cycles, and really this case is a reminder that true value adjudication is subjugated to immediate default payment obligations. So Essex really should have issued a pay less notice against interim application 23, despite the fact of a true value decision on interim application 22. Another point that's quite interesting about this case is that Essex also sought a stay of enforcement based on perceived insolvency risk. So they felt that if they were to pay interim application 23 by default, there was a risk that Bexheat would go into insolvency and be unable to repay that on a subsequent true value application adjudication in respect of interim application 23. But that wasn't upheld either. Next slide, please. Okay, so the next case we're looking at is Advance versus Eniska. This was May 22. So this was slightly the other way round. You've got interim application 24 in October and interim application 25 in November. Unfortunately, there was only a pay less notice in relation to interim application 25. So interim application 24 had gone unanswered effectively. So the pay less notice for application 25 referred to interim application 25, but was still technically on time. It was a day before the deadline for a pay less notice against interim application 24. So the adjudicator found, when it was referred to default payment adjudication, that the pay less notice, which referred to interim application 25, was not effective against interim application 24. So effectively, the notified sum was payable by default, irrespective of the fact a pay less notice had been issued. On enforcement, that decision was upheld because notices should refer to interim individual payment cycles. You can't issue one pay less notice and expect it to relate to two different payment cycles, even if the periods overlap and it would have been on time for both. Because the pay less notice referred to interim application 25, it couldn't be said to be in substance, form and intent, which are the magic words in any argument as to pay less notice validity. It couldn't be said to be a pay less notice referable to interim application 24. So really, it's another hit on the head with a hammer. We have to be issuing valid payment and pay less notices on time in respect of each cycle. And really, I think you have to recognise that the payment mechanism is king. Don't get distracted by any other disputes that are ongoing at the time, whether they might be in adjudication or not. Diarise those deadlines and make sure you issue them. Next slide, please. Another adjudication case we've got here, it's this time in relation to the jurisdiction of the adjudicator and natural justice points. This was Liverpool Council versus Viam Limited. It related to an NEC 3 call-off contract under a framework agreement agreed in 2019 for highway works. There had been an error or inconsistency in the rates for temporary fence maintenance, and that resulted in an adjudication notice being issued. There are a couple of issues with the adjudication notice, and you may know how key the wording of an adjudication notice is to an adjudication. It's one or two sides of A4, but it's really important that the wording's bang on in order to ground an effective adjudication. In this case, the notice hadn't been addressed to the specific representative of the local authority that had been noted in the call-off contract, and the notice also referred to both the framework and the call-off contracts as being relevant when a notice should only refer to one contract. So these points were taken when resisting enforcement. The Viam had started the adjudication, but unfortunately they went into administration the day before the decision, and the administrators took the view that they would take no part in the enforcement. Quite unusual, really, that the adjudicator was permitted to participate in the enforcement hearing if he wanted to, and he did make written representations via his solicitors, and that is relevant to him being able to recover his fees as well for the adjudication. So next slide, please. So it was found that the remedy was upheld by the adjudicator was under the single call-off contract into which the framework was incorporated. So the court resolved the argument about the notice referring to two contracts by interpreting it as one, essentially. The court rejected the argument that the adjudicator hadn't dealt with the parties' key points. They found that he had. But they did find that he hadn't raised a decisive point regarding the schedule of rates to the local authority's attention before he made a decision on it. He should have raised that point and invited comment before he made a decision. And on that basis, it was found that there had been a breach of natural justice and that the decision was unenforceable for procedural unfairness. So the key takeaway from this really is that in adjudication, it's rough justice, and it doesn't matter if an adjudicator is right or wrong, but it does matter that that they've got proper jurisdiction under the notice, and that there's no procedural unfairness or breach of natural justice, because otherwise any error made by the adjudicator is within his jurisdiction and is binding on an interim basis until someone goes off to court and litigates it. Next slide, please. I think that's me done. So we'll be moving over to the Q&A session now. I'd like to invite my colleagues, Catherine, Katrina and Matt back for the Q&A session.
Thanks, Emma. Great, we've got everyone back. So I'm just having a look through the questions. Thanks for submitting those while we've been talking. First one for Katrina, I think. This question, Katrina, we have suggested providing the JCT standard form funder collateral warranty on a scheme we are working on, but this has been rejected. Could you suggest why that might be?
Thank you. Well, I think there are generally lots of precedent forms of warranty published, and we would always generally advise against using those forms. So far as the JCT warranty is concerned, this is principally because certainly funders will require a copyright license to be granted immediately, whereas I think under the standard JCT it's conditional on payment of all sums due under the contract. And if a funder has to exercise a right of step in, then it will want to ensure that it is able to copy and use and reproduce those documents, notwithstanding any dispute as to payment under that contract. And I think also, unless the particulars of the JCT warranty are populated correctly, additional limitations of liability can be imposed. I think there may be some net contribution clauses from memory, that sort of thing. So that's perhaps why, although obviously funders have their own distinct requirements that invariably we have to bow down to anyway. So
Sure, that actually leads on to another question we've had, which it relates to net contribution clauses. So perhaps I can stay with you. The question is, my architect says that their insurers require net contribution clause in the warranty. Should we accept that?
So historically the answer would be no, and that's generally because a net contribution clause would require a beneficiary to pursue each and every party who has contributed to the loss in order to obtain full recovery, as opposed to pursuing the beneficiary who has, the best financial standing, has caused a loss. It would generally be the contractor in the first instance, and then requiring the contractor to pursue any other party as a Part 20 defendant in respect of that liability. So our first response is always no, don't accept net contribution clauses, but they are creeping back in more and more, and I think this really depends on the negotiating position of the parties and who the beneficiary is. Certainly funders again will insist that net contribution clauses are struck out of any warranty, but other beneficiaries may be more inclined to agree.
Sure, there's also some insurers that push more heavily, isn't there, for those clauses than others, which are more challenging to bat back.
Definitely.
Thank you. Matthew, you mentioned, if I can move to you, we mentioned a new moratorium procedure under the Insolvency Act, and you commented that hasn't been much take up, and someone's asked the question of why you think perhaps that is, that it's not being used very much.
Sure. The new procedure requires the input of an insolvency practitioner who The insolvency practitioner is the monitor of the moratorium, and he's under obligations to report to the court, and he has to certify to the court that there is a good chance that the company as opposed to the business will survive. In most insolvencies, the company falls by the wayside, unfortunately, even if the business itself survives. So there's quite a lot of disquiet within the insolvency profession and amongst insolvency practitioners about certifying these moratoria. And that's why I think there's only been a handful since they came in almost a couple of years ago.
Okay, thank you. Let's see what else we've got. Emma, sticking with an insolvency question, but if I can come to you, there's a question about payment to subcontractors. Can you have a clause allowing you to only pay a subcontractor if you get paid?
Well, case law confirms that you can't have a pay when paid clause in your construction contract. However, there is an exception for insolvency situations. So if it's limited to an insolvency situation, then any such clause would be enforceable, yeah.
Thank you. How are we doing for time? Yeah, we've got a few more minutes. Also, Emma, if I can stay with you again, because I think you've had some recent experience of this question. So the question is, what happens to the obligations of subcontractors for their works in the event the main contractor becomes insolvent and there are no key subcontractor collateral warranties that the employer can rely on?
Yeah, that is a difficult situation for an employer. For example, where the main contractor's gone into administration or insolvency, you're then left with having to do a deal with the successors, i.e. the administrators or the liquidators, in return for assignments of the relevant subcontracts. And they're not obliged to cooperate in that. So invariably this involves agreeing the termination account earlier or crossing their palm with silver. So yeah, it's not ideal, but it's better than nothing.
There are ways around. Yeah.
Yeah.
Thank you. Back to Matt, please. This question, you mentioned about winding up petitions and how they can be a problem. If you've made a payment, a question has come in about whether it's possible to find out if there is a winding up petition that has been issued.
Yeah, that's very important. If you've received a payment from a company which is subject to a winding up petition, if that company is subsequently wound up by the court, that's a void payment and will have to be handed back to the liquidator. And that's part of the general pari passu principle, trying to treat all creditors equally. And for the purposes of winding up through the court, the start of the liquidation is always deemed to be the date that the petition was issued, rather than the date of the winding up order. And that's the reason for the rule. So it's very important to find out if companies have winding up petitions outstanding against them. There are two places to look. The winding up petitions have to be advertised in the London Gazette, and it's quite easy. That's all online, the London Gazette. Just click on insolvency search, put in the name of the customer of yours, and if there are any insolvency filings against it, it will come up. But that only happens several weeks after the winding up petition has actually been issued at court. So to get a more thorough search, you need to do a search of the central index at the High Court. That's not something anyone can do in person, other than through a credit reference agency. So you can either do a one-off search, or there are companies out there who do standing searches on counterparties for you. So as soon as there's a notice of administration or a winding up petition, the credit reference agency will pick up on that and notify you of that, and that will tell you that information several weeks before it appears in the London Gazette. And that may be very important information to stop you extending further credit to that client of yours.
Absolutely, thank you. Katrina, if I can come back to you, another one relating to your warranty discussion. The question is, we've included an equivalent rights of defence clause in our precedent warranties. but we keep being asked to exclude rights of set-off and counterclaim. Why is that, and is it acceptable?
Thank you. So from a beneficiary's perspective, excluding rights of set-off is going to be key in accepting an equivalent rights of defence clause. And that's typically because they'll want to ensure they're able to recover all of their losses that have been incurred in respect of your breach of that warranty. And if the right of set-off wasn't excluded, that could effectively allow the warrantor to offset their liability to you under that warranty, to the beneficiary under the warranty, if, for example, there was a dispute with the employer under the main contract. So I think there was a case, a famous case years ago now, about a car park, the Safeway case. And in that case, the warrantor was effectively able to avoid all liability to the beneficiary under the warranty because the employer hadn't paid sums due under the contract. And that obviously negates the purpose of the warranty so far as the beneficiary is concerned. So yes, make sure you've got equivalent rights of defence, but equally, yes, you can exclude rights of set-off.
That's great, thank you. Okay, I think I'm conscious of time and we're getting very close to 12. So I'm going to leave it there for today's session. Thank you for everyone who's joined the session. When the session ends, you'll receive a feedback form and you can add any other further questions you'd like us to answer on that. We really appreciate if you're able to complete that for us. Thank you for joining, and the next date for our winter webinar will be the 17th of November. So there'll be some information coming out for that shortly. So thanks very much, and hope you all have a good day. Thank you.